So before we begin, let me share the agenda for this evening. Stand by while I share my screen. Okay, so here's the agenda. We'll begin with calling the meeting to order and roll call. We will then move on to our consent items for this evening, follow with our presentation on the Brown Act training. Item 5 is our public comment section for the public to provide comments on topics that are not on the agenda. So let's begin our meeting. For the record, it is Thursday, June 24th, 2021, and the time now is 6:08, and this meeting is called to order. Next, I will ask Halima to conduct a roll call. Halima, please.
Okay, Parvin Ahmadi. Here. David Berman.
Here.
Sharon Boholman. Shanita Chu.
Present.
Bruce Doogie.
Here.
Rachel Factor. Daniel Leary.
Here.
Carmen Lopez. Aaron Salas. Rebecca Stanek.
Present.
Cindy Torres.
Here.
Nikki Went.
Here.
Matt Wayne. Michael C. Lewis. Okay, so we have present 7 members.
Okay, do we have a quorum for tonight's meeting?
Okay. We have, that's half of our members.
And how many do we need?
50%.
Yeah, is that what we need, half?
I think 50% is, I think we need over half.
Over half, okay.
Yeah, we need
okay, well, since it doesn't look like we have quorum.
Oh, you know what? We have 8.
We do have 8, okay.
Yeah, so we do have a quorum today.
Okay, well, thank you. That's good. So we can move on to our consent items. So let me put the agenda back on the screen here real quick. So we listed 2 consent items, action to approve the action minute for the December meeting and the March meeting. And I just found out this morning the action minute for the March meeting was not distributed to the committee members. So we will only be asking you to approve and discuss the meeting minute for the December meeting. So to begin, I guess I'll open the floor for any comments or questions from the committee about the December BPAC meeting action minute. If you have questions or comments, committee members, please raise your virtual hand and I will call on you. Okay, I don't see any hands raised. So we will now open public comments for this item. If you would like to provide comments, please raise your virtual hand and I will call on you. If you're joining by phone and you have comment, you may dial *9 to raise your hand. When I call on you, I will unmute your microphone and you will have 3 minutes to speak. Before providing your comments, please state your name, the city from where you're calling. And let's see, let's take a look at the attendees here. Oh, hang on one second. I see Sharon over in the attendees list, so I'm going to promote her to a panelist here real quick. Stand by.
We have Michael Williams. He's the 510 number.
Oh, is he? Okay.
You can promote him when he's on a phone, but
Okay, I see.
Okay, can you hear me now?
Hi, Sharon. Yes, we can hear you.
Okay,
Thank you.
good. So I'm present. Thank you.
Yeah, thank you. All right, let's do this. So I'm going to go ahead and open up for public comments, and we have one speaker from the public. And let me unmute your microphone. And let me share my screen here. Okay, Roy, go ahead.
Yeah, Rick, I had actually raised my hand to comment first on the previous agenda item. So I don't know if we can go back to that one before I comment on this one.
What was the previous agenda?
One was roll call.
Okay, I'm not sure if we have public comments for
Do you have
that.
public comment on any item on the agenda?
Not sure if we have one for the roll call. But you know what? Go ahead. I'll let you speak on that one.
Yeah, it's on the agenda.
If it's an item on the agenda, you have to allow public comment on it.
Okay.
So I believe I get 2 separate 3 minutes, Rick. Yeah.
Yeah. Go ahead.
So on the roll call, I wanted to note that there's still fairly low attendance at these meetings. The December meeting just made quorum of 8. The March meeting did not have a quorum. I think it had 6 or 7. And this meeting seems to have 8 or 9. There's 15 members in total. So for the record, I just wanted to note that the attendance is continuing to be low. And if you want to address it, the question would be, what action is being taken to follow up with members that consistently don't attend the meetings?
Okay, thank you.
That was on the first item. What do you want me to do now on the second item? Okay. Yes,
yeah, go ahead if you want to have comment on the December action minute.
Yeah, just related to, I'm not quite sure logistically how you're going to do this, because several of the people present today were not present in December. So although you have a quorum today, you do not have a quorum of the people who actually attended the meeting. So I'm not sure how people who did not attend the meeting could be voting on the minutes. So maybe if logistically you could explain to the members, if they did not attend the meeting, should or should not they be voting on the minutes to approve them? Thank you.
Okay, thank you. All right, let's see. So let me stop sharing here. Hey, Michael, can you hear me? Michael? Halima, you said that 510-760 number is Michael, right?
Yeah, right. Can you hear me
yes,
now?
we have a total of 10 members present.
Okay. Oh, hey, Michael, there you are. Okay, so it looks like you are able to join as the panelist. That's good. Okay.
Okay. Yeah, I can't get my system. It's the first time I've had issues with it, but it happened today. So there we go.
All right. Thank you. Hang on, lost my screen here. So that was all the public comments we have for the December meeting. If you are not present at the December meeting, you have the option to abstain when you vote on the action minute. Okay. So I guess at this time, does any member would like to make a motion about the December action minute?
Yes, I move for approval of the meeting minutes for December meeting.
Thank you, Dan. Do we have a second?
I can second it.
Thank you.
You're welcome.
And so we have a motion to approve the action minute. Halima, if you would please conduct a roll call vote for the motion.
Parvin Amadi,
Yes.
David Berman,
Yes.
Sharon Bahoman,
Abstain?
Nikki Went,
Abstain.
Janita Chu,
Present. Yes.
okay, Bruce Doogie,
Abstain.
Rachel Factor, Daniel Leary,
Aye.
Carmen Lopez, Aaron Salas, Rebecca Stanek,
Aye.
Cindy Torres,
Aye.
Matt Wayne, Michael Williams.
Aye.
Okay,
So what was the result? How many ayes?
so we have Parvin Amadi. Let's see, we have 1, 2. We have 6 ayes. We have 3 people who have abstained.
Okay.
Oh, we
So
have, yeah, we have 7 ayes and we have 3 who have abstained.
okay. So we have 7 ayes, 0 nays, and 3 abstains. So the
Yes.
motion passes. Action minute for the December meeting. So like I said earlier, we apparently did not provide the action minute for the March meeting. So we will table that one for the next BPAC meeting in September. Okay, moving on to item 4 on the agenda is our presentation. So tonight we've asked our Deputy Counsel, Kathy Lee, to provide Brown Act training. Kathy, if you're ready, I will turn this over to you.
Great, thank you. Let me see if I can share my screen. Okay, good evening, everyone. As Rick said, my name is Kathy Lee, and I'm from the Office of the County Counsel. I'm one of the attorneys who works in that office. Thank you so much for having me at this meeting. I am pleased to be here and pleased to be able to provide some background and hopefully some helpful tools for compliance with the Brown Act. I have given this presentation before. I think the last time I gave it was to the Tree Advisory Board, who advises the Director of Public Works on matters relating to the tree ordinance, but that was many years ago and in a live conference rooms. This is the first time I've given this presentation over Zoom. And normally when I give this presentation, as you'll see, there are some hypotheticals. I would normally, solicit a lot of participation, but given the format of today, what I'm going to suggest is that, I just take you through the presentation. If you have questions or if something's unclear at the end, I'll ask for questions or comments. We can always go back to anything that you didn't understand. But I think it'll be a little bit easier to run and easier for everyone to understand what's happening if we get through the slides first. And then if there are any questions or comments, we can reserve those for the end. But if you have a piece of paper or a pen, you might want to just write them down. I don't mean to lose anyone's thoughts or lose anyone's questions, but I think that will allow us to move through without a lot of crosstalk and without, hopefully too many technical difficulties. For those of you who don't know, the Brown Act is part of one of many open government laws. And so there are a number of laws relating to open government. One example is that as recently as 2004, Prop 59 passed and codified in the California Constitution that the people have the right of access to information concerning the conduct of the people's business. And therefore, the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. And there have been laws on the books sort of in this vein for some time. What happened in the 1950s was the San Francisco Chronicle ran a sort of 10-part investigative series on local agency governance. It was titled Your Secret Government, and the title gives you some indication of the contents of the stories. The series documented a bunch of secret meetings of local agencies that were taking place in spite of an existing law that required that agency business be transacted in public. So this was one of many things that galvanized the passage of the Brown Act in 1953. I have a lot of information to provide. I don't want to overwhelm anyone, particularly those who aren't perhaps as familiar with the Brown Act as others might be. But there are some basic principles that can sort of help guide you into the right lane in terms of compliance. One thing to remember is that courts, in interpreting the statutes, including the reach and the exceptions of the Brown Act, construe the public's rights broadly and will narrowly construe the government's right to conduct meetings outside of an open and public setting. So the exceptions that are in the Brown Act are read pretty narrowly by the courts. And if there is a wobbler where, there are some factors that point one way and factors that point the other, the balance tends to tip toward public access. And if there is an exception, the burden is usually upon the agency to support and justify the exception. And in general, if you believe that an exception exists, there should be some statutory language that gives you the foundation or the basis for that exception. So the general rule, and fortunately, the Brown Act generally can be boiled down to a basic rule, which is that all meetings of a legislative body shall be open and public. And open and public are really central words, and when in doubt, you can always return to the open and public piece of that rule, and you'll usually be pointed in the right direction. So the idea is that when a body is deliberating and acting on public business, it has to do so in an open setting. And we can talk about a little bit more in this presentation about what that might mean. And a lot of the requirements that we're going to talk about today just flow down from that general principle. And as you'll see, the basic rule can seem simple, but sometimes in implementing the rule, you'll find that the requirements can be counterintuitive or not seem familiar in terms of the norms of business you might be used to from the private sector, from socializing, from community organizing, where you have pre-meetings, there are group emails, there's long text chains where everyone's on it, everyone's replying. There are working lunches, you have conference calls. These things are all so normal and ingrained in how we do business that some of this might seem somewhat foreign at first, but the rules are generally fairly straightforward. And I understand from staff that there may be some questions about what is a legislative body. That's one of the first pieces of the rule, that the meetings involve a legislative body. And the statute provides some definitions. The first one, which is always going to be a legislative body, the governing body of a local agency. So you have your board of supervisors of the county, you have a city council for a city, you have a board of directors of a special district. Those governing bodies will always be considered a legislative body under the Brown Act. But the Brown Act is not limited just to the governing bodies. The definition of legislative body is defined more broadly than that, and it includes permanent or temporary decision-making or advisory commissions, committees, task forces, and boards that are created by a legislative body. It also can reach some governing bodies of private organizations, and there are specific rules pertaining to those. They're not relevant here, so I won't get too into them because it's very easy to get into the weeds on this subject. But I include it just to point out that when you hear the term legislative body, you might assume that means, oh, that's the Board of Supervisors. But the definition in the statute reaches more broadly than that. The Brown Act also doesn't make every single meeting concerning a matter of public business a Brown Act meeting. There are things that are definitely not a legislative body. So you have a single member of a legislative body who has a committee that he or she convenes to advise that particular member. It's not a Brown Act body. You have sort of what we would call like a temporary or ad hoc committee, an advisory committee with a temporary assignment, like interviewing candidates for a vacant position, less than a quorum of a legislative body. It's not a legislative body. So we've gone over the actual, what the words of the statute say, but that you can find that can still leave some gray areas. And I've taken this little screenshot here from an online guide to the Brown Act, which is from the League of California Cities. And this guide is authored by various city attorneys and attorneys who are from the League itself. So it's a pretty good guide to the Brown Act, and it is, although it is authored by attorneys, it is geared towards the layperson too. And it is designed to sort of help people figure out compliance issues. And I found it to be a really useful resource. But they include some hypotheticals in this guide that I include just to show that as with anything in the Brown Act, there can be gray areas and questions. So one of the hypotheticals that they give, and I know that the text here is really small, so I'll just go ahead and I'll read it just that everyone can hear what it says. So here's the hypothetical question. During a meeting of the city council, so the city council is a legislative body, the council directs the city manager, so the city manager is staff, not part of the legislative body, right? The council directs the city manager to form an advisory committee of residents to develop recommendations for a new ordinance. The city manager forms the committee and appoints its members. The committee is instructed to direct its recommendations to the city manager. Does the Brown Act apply to this committee? Now, a lot of people like when there's a direct yes or no answer. And I can tell you from personal experience, people don't always appreciate when a lawyer you ask a lawyer a question and the answer is possibly. But the answer that the guide provides here is possibly. Because even though the committee is appointed by staff, develops recommendations that go directly to staff, and is otherwise controlled by staff, the direction from the city council might be enough to bring it into the Brown Act as a legislative body. And one of the practice tips that this guide provides is that the prudent presumption is that an advisory committee or task force is subject to the Brown Act. And so here's where it goes even a step further from possibly. Even if one clearly is not, it may want to comply with the Brown Act. And the reason that the guide gives as a suggestion for this practice tip is that public meetings may reduce the possibility of misunderstandings and controversy. So even though there's a statutory definition, you might have these buckets where you have clear Brown Act bodies, for example, the governing body of an agency. You might have bodies where there are some indicia that it is a Brown Act body. Maybe there's some direction from a legislative body. Maybe there's some action by a legislative body. But then there are other indicia that suggest that it's not a Brown Act body. And even still, you might have some bodies that are clearly not Brown Act bodies. And it can be a very fact-specific question. So one of the challenges is that if you look at what a court might say, you know, case law on one body is not necessarily reliable authority for saying yes or no with respect to another body. So you have these different buckets, and fortunately for you, you don't need to worry too much about it because the agency has made the determination that it's going to comply with the Brown Act for this committee. And there's certainly different buckets, different tiers. And while I might argue in front of a court that, you know, civil and criminal remedies and penalties might not be appropriate for Brown Act violations with this body, I sure might. You know, there might be some indicia with this committee that it's not a Brown Act body. There's still enough reasons for the agency to determine either on its own or if it's in a gray area that the body is going to comply with the Brown Act. And I want to point to that last statement in the practice tip, which is that public meetings may reduce the possibility of misunderstandings and controversy. So you can imagine, well, if you have a large body like this with many members, if some members think it is a Brown Act body and others don't, that doesn't necessarily lead to an effective, fully functioning committee. It can be helpful just to have a rule and follow it. Or for example, if the agency is looking to increase public participation on, you know, these are issues where public participation really matters and it's challenging to get people to participate. Sometimes following the Brown Act might be one way to do that. There are many reasons outside of the law and what a court might say for an agency to determine that following the Brown Act is prudent either to manage legal risk or because it's just a good practice for that particular body. So I know that was a subject of some interest, so I wanted to cover that. If you guys have questions, I'm happy to cover them during the questions portion. So that comes to the next question is, what is a meeting? So a meeting is defined by the Brown Act as when the majority of the members are present at the same time and place, and they hear, discuss, or deliberate on business, or they take an action. But I do want to point out in focusing in on the words hear, discuss, or deliberate, that a meeting can happen even if there is no formal action taken, that just discussing a matter within the body's subject matter jurisdiction can constitute a meeting under the Brown Act. Non-meetings are set forth by specific exemption, but if it's not covered by an exemption and you're hearing, discussing, or deliberating on business within the body's jurisdiction, then you should think about that as a meeting. So what is not a meeting? A majority of the members can still go to social occasions, conferences, and community forums so long as they do not discuss business privately and out of an open and public forum. So, you know, your 4th of July parades, your weddings, your opera performances, if you happen to run across a quorum of your fellow committee members, that does not necessarily constitute a meeting. You can attend those things so long as you do not hear, discuss, or deliberate on business within your jurisdiction. So here's one of the hypotheticals that I have. So you're at a road design conference, and it's a big conference. Several other members of the BPAC are there. There is a presentation that has a discussion on bicycle lanes. It's directly pertinent to issues before the BPAC. There's a buffet table. I mean, I'm imagining post-COVID, there's a buffet table and you say hello and you're exchanging cookies and doing all the things we used to do, exchanging pleasantries with the other members while you enjoy your hotel snack. Is it a meeting? No, right? Because you're not hearing, discussing, or deliberating on business if you're just there and you're happening to see each other and you're not discussing business amongst yourselves. What if you talk about the presentation at the buffet table? So that you might start getting into more of an issue, right? Because that is an area that's directly within your jurisdiction. If you're starting to discuss or deliberate matters that are pertinent to what you work on there, you can start running afoul of the Brown Act. Here's another example. You're all invited to a private luncheon hosted by the local Rotary Club because members of the club want to discuss approaches to bicycle safety, and they want to discuss these matters with you informally all over a lunch table. Now, is this separate organization's luncheon a meeting? It would not be a meeting if you didn't discuss matters within your jurisdiction. But if you're being called there and the idea is to have that discussion with all of you within your subject matter jurisdiction at the same time, then that does start sounding more and more like a meeting. Probably best to avoid that situation. You can still attend committee meetings or meetings of other agencies if you attend only as observers. Remember, it's that hearing, discussing, or deliberating on business that's within your jurisdiction that becomes problematic. So if you're just going to observe as part of learning what's happening, part of your due diligence, that isn't the issue. It's when you get together in the parking lot afterward to talk about things that you can run into issues. So my use of the example with the parking lot is partly to show you that the idea of a meeting isn't just sitting at a conference table, someone organized a meeting, that some of the prohibited meetings under the Brown Act reach more broadly than that. So under the Brown Act, a majority of members shall not, outside a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. So I want to take a moment to focus on the word serial when we talk about serial meetings. So the idea being that you cannot evade the requirements of the Brown Act by sort of constructing a meeting, even if all of you are not there at the same time. And there are two variations on this theme. One is called daisy chain, and that's sort of the telephone game where one person calls the next, that person calls the other person, and so on down the line until eventually everyone is aware of everyone else's views on a subject. You've sort of manufactured a meeting, even though there wasn't a conference call of everyone together at the same time. Stringing together those communications through serial actions is still a prohibited meeting if it's not noticed and agendized. There's also the idea of hub and spoke, and this is and I'll focus in on the word intermediaries, where you either have one person from the legislative body or someone else, maybe a staff member, maybe a member of the public, maybe someone else, go and reach out to each different committee member, and then eventually, sort of be the conduit to say, here's what everyone's thinking, this is how everyone's feeling on this subject. That is also considered a meeting. It's not limited to in-person, so conference calls, emails, those can all function as prohibited communications and meetings. So you can't avoid the Brown Act requirements by using the phone, by using email, group text, by using different polling software, that kind of thing. Any discussion or deliberation on a matter within your subject matter jurisdiction should happen within the context of a Brown Act appropriate meeting. So here's one hypothetical. You can, for example, schedule a special meeting or schedule a meeting, and that's not a that's not a prohibited Brown Act communication. So the hypothetical is emails are exchanged to schedule a special meeting. One member sees the proposed meetings and replies all to the email. I can't support this proposed policy for the following reasons, and I don't think we should have a special meeting because I don't support this program. Reply all is one of those functions that, as an attorney, it is just a pitfall for the unwary, and in the context of the Brown Act, it can be really dangerous. So the reply all on scheduling matters would be fine, but a reply all that gets into the substance and starts discussing, deliberating matters within the subject matter jurisdiction of the body would be problematic. So what does that leave the committee in terms of getting business done? As I said, the basic hallmark of the Brown Act is that meetings of the legislative body must be open and public. So yes, you may still hear and discuss and deliberate on matters. The only issue is that they must be in open and public meetings. So an open and public meeting needs to be noticed and accessible to the public. And I'll note that this presentation, in the interest of time and given the audience, is really focused on what your obligations are under the Brown Act. There's a lot of work that needs to happen under the Brown Act that's carried by staff. So I'm going to go through these kind of quickly, but because they're not necessarily relevant to the committee. But I do mention it just so that you know that you can still have these discussions. They just need to be noticed and in meetings that are subject to notice and agenda. So agendas must be posted. For a regular meeting, it's 72 hours in advance. For a special meeting, it's 24 hours. And with limited exceptions, only business that is on the agenda may be transacted. So that ensures that any member of the public will know what is going to be discussed and deliberated on in advance of the meeting and can determine whether he or she wants to attend at all, what comments that person might wish to make. It is a way to ensure the accessibility of the people's business. When we talk about those limited exceptions, as you can see from your own agenda, every agenda has to have an item for public comment for matters that are not on the agenda, but that are within the subject matter jurisdiction of the body. So, one issue that can sometimes come up is that people from the public who have no idea about the Brown Act may come and during that agenda item may ask questions or have important issues that they want answers for. And, that can't be subject to discussion at that meeting. However, the Brown Act does permit a brief response to public comments or questions on non-agendized subjects. And that should be read very literally, brief response. So you can direct staff to place it on a future agenda, for example, or refer a question to knowledgeable staff for a brief follow-up or status update, or request to report back. The key is to avoid, as I said before, the discussion, deliberation, or action on any non-agenda item. So if you keep that concept in your mind, that should steer you right in general. When it comes to the agendas and the board or committee materials, the agendas need to have a brief discussion of every item to be discussed to be an agenda item. Closed session items have to be listed, and for this body, closed session is almost certainly never going to be applicable. So I think it's fair to assume, unless there are some very unexpected circumstances, that the rule should be open session. I don't foresee any possibility of this body having a closed session. As I said, you have to include time for public comment, both on the items on the agenda and on items that are not on the agenda. Materials distributed to the board are public records, except for matters that are subject to the attorney-client privilege. Materials given to the board must be available to the public without delay. Okay, so the rights of the public. So, again, open and public being sort of the main components of Brown Act requirements. The public has a right to address the board or this committee on each item of business on the agenda. Public comment must be permitted before or during the body's consideration of an item. Comment on matters not on the agenda within the board's jurisdiction have to be allowed. And that is not to say that, the meeting can turn into a circus or that the public can run the meeting. The committee may adopt reasonable rules, including limiting the amount of time for comment on issues and for each speaker. And you can request speaker cards in order to organize your speakers and to have a way to call speakers in an orderly fashion. And you can request name and information for the record. However, I do note that you cannot condition the right to comment on a speaker identifying himself. So when a member of the public comes and wants to speak on something anonymously, it is that person's right to provide anonymous comment. If you ask for identifying information and the person declines to provide it, that's fine. That person can still provide comment. So you can also require time limits, as we've done here, and ask people to speak in turn. And it is also up to the committee members to ensure that the meeting is orderly and respectful. However, any limitation should be applied objectively. So one thing to be careful about is that there shouldn't be any kind of viewpoint discrimination. Whether or not you like the person's comment or not, every person has a right to comment. And while you can extend or shorten time limits, for example, if there's a very crowded agenda or a whole hallway full of speakers and you want to make sure that everyone has an opportunity to speak, you can extend or shorten those time limits, but you cannot shorten time for critical comments while extending time for favorable ones. It has to be based on objective criteria and applied equitably. So, that covers, I think, most of the topics that are going to be directly pertinent to committee members. I'm happy to answer any questions, hear from anyone. I can stop sharing my screen.
Okay, yeah, if you have a question, go ahead and raise your virtual hand. I see Bruce has a question. Go ahead, Bruce.
Hello. Thank you for the presentation. I appreciate this idea of doing the, deciding to be a Brown Act, even if it's not required. But I do want to point out that it's not required, and because the way the wording is I have the actual wording in front of me from the Brown Act, and it needs to be created by, first of all, it needs to be created by a legislative body, the action of a legislative body. And I don't think the subcommittees, the subcommittees that are, which is the unincorporated services and the transportation and planning, I don't think they're legislative because they can't create laws, because you have to be able to create laws to be legislative. But the other thing, one of the problems with conforming to this Brown Act is it's pretty constraining in terms of communication. And we also have a very limited time. We only have 8 hours an entire year to do our business if we're constrained to this Brown Act. And that's really not enough. We have so much stuff to do and so much stuff to talk about. And 8 hours a year is just inadequate. And so we would either have to, increase that or be able not to follow this Brown Act. The other thing is we don't have control over the agenda. So if we can only talk about things that are agendized, then that makes it hard for us to be able to talk about things that we want to talk about that are important and that are part of the business of the BPAC. So I just want to make those comments. I don't believe that it's a Brown Act committee, but I do appreciate that it doesn't have to be for further.
So those are great questions. Thank you, Mr. Doogie. And let me take them one by one if I can. And if I skip anything, please stop me in. I want to make sure I cover them all. So the first one is legislative body. Now, the definition of legislative body under the Brown Act is not limited just to the lawmaking authority. A legislative body, by definition, can be permanent or temporary, advisory, or decision-making. And under the definition of legislative body, the Unincorporated Services Committee and the Transportation and Planning Committee are Brown Act bodies and do abide by the Brown Act. I do want to make clear that under the legal definition of legislative body, it is not limited to bodies that make laws. So that can be, I think the layperson's idea of legislative might cause you to believe that, but that is not the statutory definition. The second item that I want to get at is what I sense is concern about compliance. And I know I've just gone through a bunch of rules and regulations that can seem overwhelming. It might make people feel nervous or concerned about their ability to comply. But I also want to put this in the context of sort of the history of the Brown Act here. It's been around since 1953. It applies to local agencies across the state of California. And local agencies across the state of California have managed to deal with some of the most complex and difficult problems over the past 70 years while complying with the Brown Act. So I do want to encourage you to have confidence in your ability to get work done even while you're complying with the Brown Act. I feel confident that you, like many other legislative bodies in the state of California, can get essential business done while having open and public meetings. So I wanted to add that as well. With respect to being confined to matters on the agenda, I think there's that's something you can probably take up with staff in terms of making sure that the discussion at the meetings is all the agenda items are there. But that is an important piece of the Brown Act because it ensures that if the staff wants to have public participation, that any member of the public who's interested in that subject knows that it's going to be discussed and can come and offer their perspectives as well. And that can give you some very useful context for any discussion that you're having. So I want to just reassure you that despite all the lawyerly talk that I've just given in that presentation, I do feel confident that as long as you stick with those basic rules of the Brown Act, that all of the committee members here can comply.
I had a comment on you say the statutory definition. Can you direct me to the statutory definition of a legislative
It's
body?
the one you provided. So it is either a governing body or it is a committee, commission, or board created by the governing body.
So I think that's where we're having some confusion.
Sorry, created by the legislative body, created by a legislative body.
Right. And so the formal action of a legislative body is what I'm talking about. So that is the part that needs to be able to make laws, because that's the legislative part. And so
there are two definitions, there are two references. There's governing body and there's legislative body.
Correct.
The definition of legislative body is broader than the definition of governing body.
The legislative body, so I'm just looking at the Brown Act. I'm hoping that you have a definition of legislative body outside of the Brown Act, because as long as it's within the Brown Act, then this idea of legislative body is not, you know, it's one that has to be able to make laws, and therefore the unincorporated services would not be one of those, because they cannot make a law because there's not a quorum of a board of supervisors. So
that's an interesting perspective. That is not how courts have looked at it. The statutory definition is the statutory definition. Legislative body includes others besides the governing body. There are multiple attorney general opinions and cases that support that. The Unincorporated Services Committee is a Brown Act body and complies with the Brown Act, as do other advisory committees that are created.
But this doesn't say they have to comply with the Brown Act in order to create a Brown Act. But I would like to, so maybe I can have a discussion with her a little bit offline.
Yeah, I was going to say I have a couple committee members with questions in common. I want to make sure I get to all of them.
Okay, so, as long as she agrees to, can I have a discussion with you, Kathy, with over email or something?
Well, I mean, I am an attorney for the county. We provide this presentation as a service because we recognize that in general, when people volunteer to serve on one of our committees, they have the best of intentions. They don't do so wanting to violate any legal or other requirements. So we provide this training to make sure that everyone has some tools to comply. But I want to make clear, I'm not anyone's attorney other than the county.
Hey, Bruce, if you have a request, why don't you send it to Daniel, and then we can take it from there. Like I said, I want to get to a couple other committee members before the evening's over. So next we have Rebecca. Rebecca, go ahead and unmute yourself.
Thank you. Thank you for this presentation. I was wondering if Kathy or maybe one of the staffers could answer the question I have about, you know, Bruce raised an interesting point about the agenda. You know, how do Brown Act bodies set their own agenda and set a meeting agenda? Is it 100% the responsibility of the chair? You know, if individuals in that, you know, if individuals on the committee are individually emailing the chair with their, you know, agenda items, is that something that's allowed under the Brown Act, or is that one of those serial meeting issues? Yeah, I guess I would just, I know that this is a thing that is done. I just want to know how it is done in compliance with the Brown Act.
Right, and the Brown Act doesn't dictate how you set your agenda. Sometimes some bodies will put as an agenda item, you know, future agenda items. You know, if they want to have a discussion or deliberation about what goes on. There are different ways to approach it. I don't think there's one that's prescribed.
Okay. Next we have Cindy. Go ahead. Cindy, I think you're muted. You want to unmute your mic?
Hello, I'm sorry. I'm having unstable internet connection tonight. And so I was kicked out a few times, so you may have answered this, so I'm not sure. But the commenting on matters not on the agenda within the board's jurisdiction. If you can say a little bit more about that and how far we can talk about things that aren't agendized.
Right.
I have
go ahead.
Bruce, about the agenda items, because I don't know if we will be able to also have input to that. As one of a member of the public stated a couple of meetings ago, we're brought to watch, not to give on things that will happen. And so the question was put forth, well, why are we here if we're just, you know, commenting on things that have already happened? Also on this agenda, I see that there is no place for the commission, for us to bring up new agenda items or comment or make comments on things that aren't agendized. The public has that. So is that supposed to be a part of this, or was it just left off this agenda? Like new agenda, new business.
So let me try and get to all those questions. I think I heard them, and I will try and hit them all. With respect to responding to items brought up in general public comment. So as I discussed, every agenda has as its agenda item public comment on matters that are not on the agenda, but are within your jurisdiction. So if someone wants to come and wants to complain about a shopping mall or something that's not in your jurisdiction, you don't have to hear that, or you don't have to hear those items. But if it is within your jurisdiction, you want to come and make a comment, and potentially, as you point out, something that you want to have on a future agenda, then they can do so. You can point out that you're limited in responding. The kinds of responses that you can give are sort of brief responses that don't involve any discussion or deliberation. If staff might be knowledgeable on something, you can direct that person to staff for follow-up. You can ask staff to place it on a future agenda. There are different responses that you can give that won't create a Brown Act violation. So you don't have to sit silent and responseless while the person asks for some kind of reaction, but you should avoid discussing anything substantive. So that's hopefully the line, is that, something that, okay, you've heard the person, maybe you plan to have staff follow up directly with that person, or get additional information for them, or provide contact information where that person can get more information. That's all completely fine. Or you can say, we'll consider it at a future meeting, or ask staff to put it on a future agenda. Those are all perfectly fine comments. As I was saying just now with Ms. Stanek, I don't think that there is anything in the Brown Act pertaining to how the committee runs and orders its own business in terms of getting items on the agenda. This committee, correct me if I'm wrong, Rick, but I believe it's staffed by Public Works. If there are questions about future agendas and future agenda items, you can communicate with staff. One item that is not a Brown Act meeting is communications directly with staff. You should avoid calling Rick and saying, Rick, what does Mr. Leary think about this item? And have you talked to Ms. Ahmadi, and have you figured out her perspectives as well? That would not be appropriate. That would be getting into hub and spoke. But if you wanted to talk to Rick and say, what's the update on this project? Can we get it on a future agenda? That would not be a prohibited Brown Act meeting at all. Does that answer your questions, Ms. Torres?
Yes, just the last one about us being able to bring up new business it's not listed on the agenda.
Right. I mean, I think you can give brief reports. So if you're, or announcements, those are also fine. If you want to say, hey, so-and-so is having a community forum, and, we encourage people to go, or we're having a town hall on this day or something, that's also fine. If you want to sort of just give some kind of like status updates, that would also be, it's a little bit riskier, but, something like, we're going to be considering this item at the next meeting would be fine. Those are all perfectly acceptable Brown Act communications.
So one thing I was hoping to do was to make a recommendation.
Yeah, Cindy, I think your audio dropped off at the end there. Before I move on to the next committee member, just to follow up on Kathy's point, in terms of agenda item, we're certainly welcome to hear suggestion from the committee. So if you have any, feel free to send them to me. We'll definitely consider it. Dan, you have your hand raised. Go ahead.
Yes. Thank you, Ms. Lee, for the presentation. Brought up a lot of things I had thought about. And one question I have, just from my past experience with the Brown Act, if I, and this might happen here because this is a different kind of committee, because most people here are advocates for bicycling and pedestrians. So you might encounter somebody like the example you gave, at a luncheon, or there's a buffet and you're talking to somebody. Oh, you're on the committee. So what do you have in common? Oh, what do you think about this particular bike lane? And you're not really telegraphing how you might vote on a certain project, but obviously you kind of are, because you're an advocate for bikes, bicycles, pedestrians. So I'm just wondering, just a little bit about the boundaries there.
Yeah. Well, fortunately in some respects, I know that it's challenging to get a quorum, for example, but that might actually help you with your Brown Act compliance, because you can have a one-on-one communication. It's not a meeting. Now, I say that with the caution of you shouldn't use that to daisy chain, right?
Yeah.
But if you run into one other committee member and you're having a conversation, because it's not a majority of the membership, even if you do start getting into more of the substantive issues, you're not going to have a Brown Act problem per se. I do advise caution, though, just because some of the communications that happen outside of an open and public meeting, despite the best of intentions, could turn into, well, I also talked to so-and-so, and I was just, I just had lunch with those 5 guys and this is what they said. And, it can, those kinds of informal communications can take turns that you never intended.
Okay. And a follow-up to that, just so other people know, I don't know if this falls into the Brown Act, but a public records request, with that, I've had people like text messages and personal emails have been requested. Is that a possibility with this committee too?
Yes, it is. So I mean, so the Public Records Act, for the most part, we probably will not have an issue with Public Records Act requests. And I reiterate that a lot of the burdens of compliance, both with the Brown Act and Public Records Act, fall on staff. So, it is a very helpful thing if you are using and relying on staff and you're not having, for example, a big group text of committee members that might start innocently that we'll just use this for scheduling and then evolve, and then you arguably have public records on your cell phone. So yes, I don't mean to spook anyone. That's not the intention of this presentation at all, but I do want to suggest that keep the communications at the meetings, and you'll find that you can avoid a lot of those issues.
Thank you.
Okay, next we have Parvin.
Yeah, I was, I think I want to better understand Mr. Doogie's question. I think I have an idea. For example, we follow the Brown Act because, I work as a part of a governance team with our board, school board. So we really follow to a T. We have, as a part of that, for example, we have a subcommittee that actually has to follow the Brown Act, even though there are only 2 board members, because they were assigned to be on that committee along with myself. So I think, and I don't want to speak for him, but I want to know if his question has to do with how were we decided to be on this committee? That makes it a body that has to follow the Brown Act.
That is absolutely relevant. If, for example, if, as you point out, your legislative body is selecting the membership of a subcommittee, then that would bring the subcommittee under, and is appointing it, that would likely bring the subcommittee under the Brown Act. I actually am not entirely sure about the appointments here, but I did want to point back to the hypothetical I gave, where the legislative body, and I think it actually is somewhat similar to a school district case where there was a very controversial reading list or something. I might be getting some of the facts of the case wrong. And the district board had said, well, we're going to have the superintendent address those issues. And the superintendent created a committee that reported directly to the superintendent. The superintendent appointed it. The committee made recommendations directly to the superintendent. I think there was maybe some parents on the committee. And the allegation was that that was a violation of the Brown Act because the committee, that superintendent's committee meetings were not open in public, and the court agreed. So I don't know that it's useful too much to get into the weeds of how, you know, which bucket is it in and how did it get there. I think it's sufficient to say you might be in the possibly bucket, you might be in the not a Brown Act body bucket, but at the end of the day, the agency has determined you're going to follow the Brown Act. Staff is willing to do all the work. I would hope that there wouldn't be resistance from the committee members to following the Brown Act.
It's actually, I have to say, it's not a bad thing. I just want to, I think, I look at the members in this committee, and I know many of you, but there are members that were added later on, and I'm not sure. I mean, what was the purpose of bringing who, like, for example, I'm here because I'm the superintendent. Matt Wayne is supposed to be here because he's the superintendent of that school district, and we have a lot of, but I don't, I can't remember who it was, that a couple of people later on. So I think it would be helpful for us to know why we are here. So that's just a separate thing. The other thing I wanted to say, I really think it would be great to have an item on our agenda item instead of every one of us bugging Rick, you and your team about, oh, let's put this on the agenda, let's put this on the agenda, because at the end of the meeting, then we can talk about what should be, because it's a new committee. Like for us, every year we know we have to cover certain things. So we already have our agenda pretty much set for the whole year. And then if things come up that we have to add, we add. So just a suggestion.
Okay, thank you. Chanita, I think you had your hand raised, if I remember right. Chanita, I think you need to unmute your device.
No, I'm going to wait. My questions have all been answered.
Okay.
All right. Thank you, though.
Thank you. All right. So I think that's all the questions and comments from the committee. We'll open this up to the public. Let's take a look here. All right. First one, we have Michael Freed. I'm going to unmute you. Michael, go ahead. You can.
Yeah, did I
buy your comment?
You hear me okay?
Yes. Okay,
thank you very much for the presentation. And my name is Michael Freed. I'm a resident of Cherryland and also on the EMAC Advisory Council for Nate Miley's office, just as full disclosure. And that's a question that the whole Brown Act thing is something that we've been grappling with in our own appointee positions. To see how we can avoid any kind of crossovers. The question a lot of the answers to my questions have already been, I think, pretty well addressed this evening. But in the process, I also came up with something which I don't know is a problem or could be a problem, is there any kind of legal statute of limitations for people who are on a committee or on a board or on an appointed position for a certain length of time, and then they term out? Is there any, and they jump from, let's say, one bucket to another, but the issues are ongoing, and any kind of changes or legislation is going to come before a body might be over a period of months or years. is there any stipulation for somebody who moves out of a position of decision maker or advisory position, becomes a member of just the public, but because they've been established as somebody involved with some of these issues, is there anything that would be a problem with them discussing things for people that are still on it? Is there any kind of waiting out period before you can actually come back in and do something else and not be accused of, part of the daisy chain or, whatever?
Right. So let me address a couple things. There is an issue. If you are,
did I make a point that you can talk about that would be pertinent?
Sure. Sorry, can you hear me?
Yes.
Okay, yeah. So there is an issue when you're newly elected, even if you haven't taken office yet. Once you're actually elected, then even though you haven't, assumed your seat, that can be that can create Brown Act issues. But once you've left and you're not a part of the body anymore, I'm not aware of any kind of waiting out period, or that there's any need for like a safe harbor time where you would need to not have communications. The other way, where you're appointed but have not yet started, can have issues. So I do want to note that is a circumstance where you should probably think about Brown Act compliance. But when you've left and you're just an ordinary member of the public, the Brown Act doesn't apply to you anymore. One thing, though, is that, again, with the discussion of intermediaries, you still don't want to be a part of a Brown Act violation as sort of the hub, as part of the spokes of a Brown Act violation. So if you've left the committee and you are now just a member of the public, you still should be careful that you're not facilitating a Brown Act violation by communicating with each different body member and thereby facilitating a Brown Act violation. It's just something to be concerned with. And the party to be concerned is most likely the actual committee or commission members or council members. But that would be the issue to keep an eye out, even as just a regular person.
You don't want to be the catalyst for something happening.
You're right. You don't want to be the conduit for, since you just served with all these other council members, you know them all. Can you go to each one and, poll them all and give them an idea of how the vote's going to go? Or, can you tell one that he's the deciding vote because the other, the other three are going this way? That would be problematic.
Mm-hmm. Yeah, so I can see the possibility of, in a sense, kind of using the rules to act as caveats for, let's say that you have a parking meeting after some event and you see 2 or 3 people that are going to be, involved with this, and you see the conversation going in the wrong direction. It'd be best if 1 or 2 of the people just get up and leave, just sort of extricate yourself from it. So there's no possibility you could have been seen there, but that would limit the possibility that somebody would bring it up as a violation.
Right, and just to address any concerns that any committee member has, these rules are not meant to prevent you from talking to your constituents, hearing their concerns. Mm-hmm. Part of doing public business is being connected with your communities, and the rules are not meant to prevent those things from happening. So, I don't mean to spook everyone, but that is the issue where, you could have people. Make sure that you're not discussing other committee members' views, and you'll probably be okay. So that's the main item.
And in terms of soliciting,
Michael, if you don't mind, I want to get to a couple other members in the public. So I'm mindful of the time here. So next we have Roy. So let's see. Hang on, Roy. Let me try to unmute you. Okay, go ahead, Roy.
Thank you, Rick, and thank you for the presentation. It was very interesting, and I think you did a great job in taking a potentially complex topic and presenting it very concisely. I do want to make a couple of comments. I think that the question of whether the Brown Act applies to this committee or not needs to be answered. And you did not give an opinion on that. And in fact, you kind of washed over that and said it doesn't matter, we're going to do it anyway. But I think it does matter because it really impacts how this committee actually functions. This committee is an advisory committee to staff, yeah? It was not formed by a legislative body in the terms you've described it. It does not provide advice to any legislative, sorry, I can't say that body. It is not there is no board of supervisor or any elected official on this committee. The committee does not vote on anything. It does not get the opportunity. This is not a committee where staff bring forward plans and people vote on whether they should or shouldn't do it. There's no voting. There's no election. Appointments to this committee are made purely by staff. You want to be on the committee, you fill in a form and you send it to them, and somehow or other they pick 15 people to be on this committee. So given there's no actual contact with anybody in the board of supervisors or any elected official, it purely provides verbal, I mean, the meetings are exactly like this discussion. Someone from staff makes a presentation just like you did. People make comments after it. Those comments are not recorded. If you look in the minutes, none of the advice or suggestions given by the committee members are actually captured or recorded. There's no follow-up on whether any of those suggestions were followed up on and incorporated into designs for anything. It really is, nothing more than a, public information service. It's presentations and some verbal feedback from people, and that's it. Yeah, no voting, no way to influence anything that happens. So given that, could you give a very clear opinion as to whether the Brown Act applies to this committee? And if it does, exactly why it does? Thank you.
Sure, and as I acknowledged during my presentation, I know that people don't like to hear the word possibly from an attorney. And I am going to go back to sort of what the League of California Cities Attorneys put in their guide, which on a committee that was advisory to staff, that was appointed by staff, but at the direction of a legislative body, that it could possibly be covered by the Brown Act. So I know that's not the answer you're looking for. And fortunately for us, we're not in front of a court right now. What I would suggest, though, is that trying to anticipate what a court would do or say is not necessarily the best way to determine your own path for compliance or what you might want to do even as a prudential matter in light of that uncertainty. You've pointed to, I will say that Mr. Taylor has brought up a lot of indicia that would suggest that this is not a Brown Act committee. That does not mean that there are no indicia that this is a Brown Act committee. And I do want to just reiterate that Unincorporated Services Committee and Transportation and Planning Committee are Brown Act bodies. They are legislative bodies under the Brown Act. And I don't think it's a useful exercise or a necessary use of time to go back, but I do know that there were many agenda items on both bodies' agendas relating to the formation of this committee. And I know that proposal may have evolved over time, but I point that out just to say the idea that there's a clear no here, I don't know that that is the case. And as I said, if someone were to try and seek civil or criminal remedies against this body for some alleged failure to comply with the Brown Act, might I go into the court and point to all those factors you just listed and suggest that maybe it would be inappropriate to assess criminal or civil penalties because you know, maybe this isn't a Brown Act body. Perhaps I would want to keep that option open just to, as a matter of being able to preserve defenses. But that's really not the issue that's before the committee, which is that the committee is going to follow the Brown Act. And, you know, I hope that I've given some helpful tools on how to do that tonight.
Okay. Well, thank you, Kathy. I think that's all the questions that we have. So.
And let me just say thank you all for your service. I really hope it was not, you know, it absolutely is not my intention to scare anyone or make anyone nervous about what it means to comply with the Brown Act. And I want to reiterate my confidence that you will be able to serve while complying with the Brown Act. So thank you all very much.
Yeah, and all, good information, Kathy. Always appreciate you keeping us and especially me out of legal hot water. So thank you.
All right, take care, everyone. Good night.
All right, moving.
There's another hand up, I think.
Oh.
Sorry. What was that?
I think there's another hand up. I took my hand down right now.
Yeah, I have my hand up. I just wanted to make a comment to Kathy's presentation that the key is that you're not supposed to communicate with the majority. So you know, the majority is 8 out of 15 on the committee. So 7 of the 15 is technically, you know, complies. So.
Right, and I do encourage you to, you know, as I was saying to Mr. Leary, I don't want you to unwittingly find yourself in a Brown Act violation. So it's very easy to go from 7 to 8, and you know, I would encourage you to focus on compliance rather than evasion. Yeah, but thank you all again for the opportunity, and I hope you have a wonderful evening.
All right. Thank you, Kathy. So moving on to item number 5 on our agenda, which is public comment. So this will allow the public the opportunity to speak on issues that are not on the agenda. So if you would like to speak, please raise your virtual hand and I will call on you. Let's see, we have Roy. Okay, Roy, I think you're unmuted, so go ahead.
Yeah, thanks, Rick. One comment just around the use of the time today for this training. This committee only meets 4 times a year, and taking up the time, you know, within the normal committee time for this training has obviously prevented the normal agenda from happening. I think most other committees and advisory bodies that require training for their members actually provide that training outside of the normal committee time, and therefore, you know, they don't impact the you know, the ability of the committee to meet and deal with its general business. So it's a little frustrating, I think, to see, not that it wasn't a good discussion today, but it's a little frustrating to see that, you know, all the time has been taken up on this that could have been done separately. And training can be provided separately to members of committees outside of, you know, the regular meeting. I just encourage you to do that in the future. Thank you.
All right, thank you, Roy. Let's see. Okay, I don't see anyone else from the public. So that brings us to the end of our public comment.
So I just wanted to make sure I have an opportunity to make a comment as well when you're ready.
Okay. I think, Charnita, you have your hand raised. Did you have something you wanted to add?
No, I just wanted to make an announcement about the Healthy Living Festival, but I was going to wait until the end.
Oh, okay. Okay, Bruce, go ahead if you want to have something.
Yeah, I just want to
comment.
Yeah, I just want to suggest an agenda item for the next meeting. Because I would like to talk about the bike lanes on Crow Canyon, because the bike plan actually calls for a Class 4 separated bike lanes, and it sounds like we're planning not to do that. And so it would be nice to at least go over what is planned and maybe why we're not actually following the bike plan. So these are the bike lanes on Crow Canyon between Castro Valley Boulevard and Coldwater, I believe. So.
Okay, we will consider it. Chanita, go ahead if you have an announcement you wanted to make.
Yes, I want to let everyone know that the Healthy Living Festival this year for United Seniors of Oakland and Alameda County is going to be held in person at the Oakland Zoo on September 30th. Now, I know we have a meeting on September 23rd, so I'll make this announcement again.
Okay.
So, but I want to let everybody know from 8:30 in the morning until 2:30 in the afternoon. And if anybody needs to contact me, they can contact me at chanita@usoac.org.
Okay. Thank you for that information.
Thank you.
All right. And Cindy, you have your hand raised. Cindy?
Hello, yes.
All right. Go ahead.
To the next agenda, the traffic.
And I think we're having a problem hearing your audio.
On Hampton Road in front of our new Cherryland Community Center.
I can't hear her.
Yeah,
I cannot hear her.
I think she said, I could hear her a little bit. I think she was talking about traffic near the community center in Cherry.
I'm sorry, I was having problems.
Yeah, I think think there's a bad connection there. Okay, well, looks like that's.
I just raised my hand. This is Michael Fried again. I live on Hampton Road, and I think what Cindy was talking about is something about bike lanes on Hampton Road or traffic control on Hampton Road or intersections or something about the new community center, opening when it does open, and being very concerned about the public access by way of pedestrian traffic and bike traffic. I think that was her question, something about, the traffic flow on Hampton Road and Boston Corner and the entry.
If there are specific concerns about that, just go ahead and contact me directly. We can take a look at it. Okay.
I'll talk to Cindy about it and see what she was going to ask.
All right. Thank you.
Thank you.
Okay. So this brings us to the end of our meeting. So again, thank everyone tonight for your participation.
I'm sorry, Rick. Can I just ask what will be on the next agenda? I heard 2 items. I know we didn't get to hear clearly what Cindy was saying, but I'm hoping that I know Bruce had an item that he wanted to put on the agenda. I know you said, I can't remember what you said.
Well, we'll consider the item. So I don't have next agenda ready to go yet. So we'll publish that when we get closer to the next meeting.
Yeah. So I guess when Ms. Lee was presenting, that's one of the things that I think is best practice. That as we are here, if you can ask if that's an item we want to have on the agenda, to go ahead and agendize it, so that it can be discussed along with whatever. I don't know what Cindy was asking. I'm just saying, she was talking about some best practices, and I think this is one of them.
Yeah, maybe maybe that's where we can vote. So we can vote on agenda items. Yeah, that's a good suggestion.
Hello, can you hear me now?
Yes.
Yeah, Cindy.
Okay, yes, thank you. I was listening to Parveen, thank you. I wanted to bring up parking spaces and possibly a stop sign to be put in near our new community center that should be opening up in a few months. Our next And so I don't know how to bring that up. Do we put that on agenda? Do I write in to you and request that beforehand?
Yeah, why don't you send that information to me? So that sounds like a traffic engineering item that we'll review, just as a daily business that we do. So go ahead and send me an email. Give me all the detail. We'd be happy to take a look at it.
Okay, thank you.
All right. Okay. Well, it's a little bit past our normal end time, so I'd like to bring this meeting to an end here. So again, I want to thank everyone tonight for participation. Next meeting, I believe it will be on September the 23rd, 6 p.m. We'll send out an agenda prior to the meeting. So it is now 7:37 and this meeting is adjourned. Thank you again for coming. Stay safe and have a good night, everybody.
Thank you, folks. And thank you to Chanita for joining from the bus.
Yeah.